Hi, good afternoon, everyone. This is Rajiv S. Khan of Immigration.com, the law offices of Rajiv S. Khan PC. Today, December 19th, Thursday, this is a community conference call, which we do every 2 weeks, and everybody is welcome to participate, ask questions. First, I will answer the questions that have been posted in our forums. Then I'll respond to any follow-ups and then any new questions. Getting started, first question is from Suresh Kakumani, who says EB1C eligibility. Came to USA in 2011 on L1B. Moved to H1 October 2012 with a different organization. Now the first organization is calling back and saying they can apply for green card. Is it possible to do an EB1? He has worked as a manager in both India and US, and the answer is yes, as long as on the date they file your EB1C application, 3 years before that, you have at least one full year outside USA working for them as a manager. So 3 years before filing the application, you must have 1 year of working as a manager outside USA for them. Okay. Um, Normally, what happens is if you enter USA working for a sister or parent or a related company of the same company, let's say you enter on L1B and you work for 5 years, and in the fifth year you want to file a green card because in fact you are a manager and you were a manager before also. The 3 years are counted then from the date you entered USA, not from the date of the application. So if you continue working with the same company, but here you broke that chain and you worked for somebody else, so it will have to be 3 years counting back from the date of the application, as far as I remember. Okay. Next question. Umber came to USA on F1 in 2002, never went back to Pakistan, working on H1B, got EAD, which is advanced parole, want to visit Pakistan. You don't need any stamp. You can just re-enter on advanced parole. All you need is your passport and your advanced parole card. Okay. What will become of my H1B status? Well, you're still supposed to be on H1B. There is a memorandum out there called the Cronin Memorandum. It should be there on our forums. You can just type Cronin, Cronin. Back in the 80s, USCIS gave an opinion that even if you travel on advanced parole, we will still consider you to be H1 status for any extensions or status purposes. So it really does very little harm in re-entering on H1, on advanced parole and continuing on H1. So even though you had entered on advanced parole, you'll be considered on H1 status. Okay. There's a little twist here that if there is something that goes wrong, then are you on advanced parole or H1? Leaving that issue aside, coming back in on advanced parole is not a problem. How long will it take to get the green card? I cannot really tell you. Can I change jobs? That depends, Umber. If your 485 has been pending 180 days and your I-140 is approved, you can take a similar job anywhere in the country with any employer under AC21. And I have a lot of material on AC21, at least 4 or 5 entries, including some fairly lengthy videos on what AC21 is. And in fact, further down, there are some questions about AC21 today also. I remember somebody from my LinkedIn connections had said they wanted some issues clarified. That also, I think, has to do with AC21. So just listen on in the conference and I'll deal with that issue further down. This is an application for 212A4 denial. Now, here what happened was their son's immigrant visa was denied because they were not domiciled and therefore could not qualify as a sponsor. See, the interesting thing is, I think the consulate is misreading the law. So you do need to get a lawyer because the law says for the purposes of domicile for affidavit of support, even if you can show that you are actively in the process of settling back down in USA, they should accept that. In your case, you have already settled down here. So act quickly on this. I don't know if our office can, you have a deadline very, very close. Let me double check that. January 10th. Yeah, we should be able to do it. We should be able to do it by January 10th. It's not a problem. What you need to do is send me an email to help@immigration.com, help, HELP at immigration.com. That's my personal email address. I'll get somebody assigned to take a look into your case. Okay. Typically, what we do is we charge you an upfront consultation, and if you end up retaining the firm, in most cases, we will apply that, or at least a large part of that consultation to your total fees. Okay, just to give you a heads up. Next question is Victor 25, priority date porting question. So you're right, Victor. Once your I-140 is approved, the priority date becomes your property, and even if the old employer revokes the I-140, you still keep the priority date. The only time you lose the priority date is if the I-140 is revoked by USCIS for fraud or misrepresentation. So that's rarely the case. You will keep your priority date, and even if you port from EB3 to EB2 or EB1, it doesn't matter which category you take the priority date to. It will apply. Okay, so if the old case was EB3 and now you file an EB2, you can carry the priority date over to EB2. That's not a problem. Revocation by the employer, by the old employer, has no effect. And you can do it across employers, clarify that as well. So if you leave this employer, go to a new employer, you have to start the green card process all over again. That's the difference between AC-21 and priority date transfer. Let me make that clear to you. In AC-21, your I-140 is approved, 485 has been pending 180 days. You don't have to start your green card all over again. You can just port your whole green card over to a similar job. But in I-140 priority date, you have to start the green card all over again, but you can take any job. It doesn't have to be same or similar. So if you were an IT, like a software engineer in your EB3 application, you could become a VP information technology, or a COO or a CTO in the new company. You'll have to start the green card all over again, but the priority date will be the same. Okay. Next question, H-1B expiring, perm pending, looking for options to stay in USA. Well, people go on to tourist visa, people go on to student visa. These are the two obvious options, but you're not allowed to work. Some people get CPT when they go into F-1 visa. Usually, USCIS is not very charitable towards universities that are giving out CPTs in the first semester of your studies. But of course, if during studies, and these are your graduate studies, the CPT is integrally tied into your academic program, it's a inseparable part of your program, USCIS will accept that with enough documentation. Okay. So your questions were, your H-1B is expiring in 2 months. You filed perm, 7 months, no response from DOL. Your attorney told you that you need to have perm and I-140 approved before my H-1B expiration. No, that's not true. You see, you'll be eligible for H-1B extension after 5 months anyway, because H-1B extension beyond 6 years is done under two sections of AC-21, 104 and 106. Okay, one section deals with how long ago was your labor cert filed. So it's tied into the time of filing. The other one is tied into the stage of filing. If you reach the I-140 stage, we don't care when it was filed, you get your 3-year extension. But once your 1-year anniversary of labor cert is reached, you get 1-year extension. So in 5 months, you'll be entitled to 1-year extension. Does the leaving of the country have any impact on the perm and I-140? No, it does not. Only question is, make sure that the employer has the ability to pay wages. Your lawyer should be able to brief you on that. That's a long discussion. But essentially, you're not working for the employer. Do they still have money to pay you? Can I come back again from India once my I-140 gets approved? You'll be back in 5 months, because when they can apply right now for your extension, which will be effective 5 months from now. Okay, because H1 extension you can apply 6 months ahead of time. You can only come back after 5 months, but they can apply right now. Okay, and you're not subject to the quota. Can I work in India for a different employer? Yes, you can. Can I work for a company in USA remotely? Yes, you can. Any other way? I just told you about that. Next question. Spouse is very abusive. I need advice. Well, you can get public assistance um, as long as it's not a means tested benefit. Write that down. If something is not a means tested benefit, getting that does not affect your green card. Okay. You can also get copies of documents of your case if you file a Freedom of Information Act request. Freedom of Information Act request. Okay. Um, you need a copy of your affidavit of support, etc. You should be able to get it under a Freedom of Information Act request. There's a form for that on USCIS website. Just go to their list of forms and just type in your browser search FOIA, FOIA, Freedom of Information Act. Okay. Do that form. It's a free filing. It doesn't cost you anything. Man Kumar says, got my H-1B stamped in home country for a genuine in-house project. Employer wants you to start at a different project after you travel to the States. That can be fraud. Because if you enter USA saying or implying to the government, I'll be working in-house, but all the while your intention is to go work somewhere else, USCIS and CBP can consider that to be a fraudulent entry. Okay, so you should not enter in my view like that. Should I work for another company when the new LC and H-1B amendment is in process? Should I wait? I think you should just wait outside. My H-1B is stamped through company A. Can I join to a... Well, you are cap exempt, but you'll have to go for visa stamping and new H-1 through another company. So if you want to join company B, they'll have to file an H-1 for you. You should be cap exempt. You'll go for visa stamping again. That's the smart thing to do. And then enter for company B's visa. And you're not subject to the quota. Can I travel to US on stamp visa of company A and then get H-1B transferred? No, that could be fraud. Can this cause problem or negative point in my green card filing? Like I said, that can be considered to be fraud. By the way, any fraud or misrepresentation or attempted fraud or misrepresentation in an immigration benefit is a permanent bar from entering USA. Permanent bar. It can also be a criminal offense. So be careful with that. Now you might do something innocently, it might become a problem. Manish 0201. Husband recently got H-1B stamped in India. My H-1B petition is also filed by the same employer. Has been approved but not stamped. I have a business visa and L2 visa stamped. Below are my few queries. Should I appear for H4 as I would not start working immediately after traveling to the US? Yes. If you're not going to start working immediately, you should go for H4. I was hired in the US for a MNC, I don't know what that means, and worked there, multinational corporation, okay, and worked there till 20 July 2013. Got a leave of absence, returning back. So technically, I was an employee of the MNC. What should I answer if I'm appearing for H4 stamping? Am I working now? Well, you're not really working. You're not getting paid. You're not working. So you can say no, I think. If I decide to appear for H1B stamping, should I? Well, I do not know the answer to that question. I think even if you're working for the same employer, your husband, it should not be a problem. What's wrong with that? If it's a genuine case, let them be suspicious as long as you have enough documentation and the case is genuine. I don't let those appearances worry me. What visa stamping should be preferred? I think H4 is preferable for two reasons. One, it's easier, and two, you are not going to start working immediately on H1B when you come in. By the way, the employer has to start you on within 30 days after you enter, or whenever you present yourself, whichever is earlier. But you can ask for extra time. You can ask for 30 days or 40 days more to set up house if you came on H1B. But H4 appears to be a little bit easier case for you. Anjana Singh, B1 B2 visitor visa. I'm a green card holder. Fiance has a B1 B2 visitor visa. He's never been to the US before. Planning to get married home. Haven't decided that yet, whether we should do it here or back home. Never, never, never enter on a tourist visa with an intention to get married here. Never. That can be considered to be fraud. No, do not let them enter on a tourist visa. to get married. Okay, that's not a good situation. So the better option is either apply for a fiancé visa, which is a K1. It's going to take a few months. Or if you want to get married, you go to India, get married, and apply for I-130 as well as K3 visa. Again, it's going to take a few months, but there's nothing we can do about that. That's the right thing to do. Manoj Kumar CN, applying for GC on L2 visa. I'm on L2 EAD, working for State Department through a consultancy. Can I apply for green card if my employer is ready to sponsor? Yes, you can. Also, since I have a PhD from India, can I apply for GC in EB1 category by self-petition? I would have to look at your resume. Not everybody who's got a PhD qualifies under the current law for EB1. You can review the EB1 requirements on our website. We have everything in detail. Basak wants to know, can I-90 be filed outside USA? As far as I know, it cannot be. You have to be inside USA. But double check with USCIS. Law is full of surprises. I don't think it can be filed out from outside USA, but double check with USCIS customer service. P. Churala, L1 to H1 status change. I have a valid L1 and I-94 till the end of March. Applying for extension from company A. Can I also apply for H1 at the same time from the same company A? I don't see why not. Yes, you can. If yes, what if my L1 gets rejected and I had to go back to India before the H1 is approved? Can I still get my H1 visa by being stamped, or will it be abandoned? Oh, absolutely. So you applied for L1 extension, you applied for H1, L1 gets denied, you left country. If H1 gets approved, you can go get visa stamping and come back. By your leaving, H1 does not get abandoned. The request for change of status from L1 to H1 gets abandoned. So once again, by leaving, you haven't abandoned your H1, you've just abandoned change of status from L1 to H1. And to substitute for that, you're going to get a visa and come back. No problem at all. Hari0604 regarding L1 to H1 conversion. General question, currently in US on L1 with company A, also have an H1B approved for 2014 with B. It was applied without change of status. In case I want to move to company B, do they need to file new H1 with change of status and go through the same process? Or can they file change of status only? No. A change of status for H1 is pretty much like the same process all over again, but it's a little bit easier and a little bit cheaper. Or you can go outside USA and get visa stamping and come back. I don't know what the fees, etc. are. I'm sorry, I don't keep track of those things. There are people in my team who are much better equipped and much better. They do this all day, so they can tell you better. I don't know what the fees, etc. are. But you can calculate that from the USCIS website. That's not difficult. AKS 341. How long before termination on H1B should I file for visitor visa? Because you can file for visitor visa online, not visa but status. So form I-539 can be filed online. So let's say your H1B is expiring tomorrow. Today you could go online and file your tourist status application. Okay, so you can do it the same day. I believe I will be terminated in the first or second week of Jan 2014. I'm currently on H1B. I have an offer from an employer. My current H1B is valid till Feb 2015. Okay, if I file for a visitor visa before my current job is terminated, if I get terminated, do you think there'll be any problem? This can get complicated. I may not have enough time to go over the whole details, but I have an article on this, a detailed article on my blog. Okay, and you should discuss it with your lawyers. These are all good issues, but the bottom line is the worst case scenario, you might have to go for visa stamping. So applying for a tourist visa to cover a few days gaps is a good idea. If there's a few day gap, you can cover it with a tourist visa application, but doesn't mean it's gonna get approved. You might have to go outside for visa stamping. Okay, and an H1 change of status will not be approved unless the first is approved, the tourist visa is approved or tourist status is approved. If there's a gap in statuses or the application is still pending, tourist application is still pending, they will not approve the H1 status. They will approve the H1 and ask you to go get visa stamping. and you can go to Canada or Mexico. And you looked at some website. By the way, this information that you are pointing out is available on Department of Labor website. It's public information. How many LCAs have been filed, etc., etc. Is there something I should be concerned about? One, denied out of 24 applications in 2012. Denial of H1 or green card is not uncommon. That does not worry me by itself. Need city L1A extension denied, available options. My L1A visa and I-94 both expired on July 1st, 2013. Extension was requested on June 14th, so before it expired. RFE came. Okay. If I leave before 28 December, 180 days after expiry of I-94, then also will my presence in USA be counted as unlawful presence? Your unlawful presence, because of the timely filed extension, I don't know all the facts of your case, but it looks like it should begin on the date of the extension denial, not on the date of the I-94 expiration. Because of the timely filed extension application, your unlawful presence begins on the date the extension was denied, which is December 5th. Okay? And you are now, on December 6th, you became unlawful presence. If you stay 180 days, you become barred. If I leave before 28 December, then also will my presence in US be counted as unlawful? It is unlawful. Do I have to submit any documentation to USCIS after returning back to India? You do not. Is it possible that my employer file an appeal or motion to reconsider my case and I leave USA before 28th and apply for blanket L1A? You can, yes. Or I just leave the country before 28th, no appeal or MTR, apply for blanket, you can do that also. What is better? I don't know what the ground of denial is. After leaving the US within 180 days of expiry of I-94, if I apply for a blanket L1, should I mention yes or no to unlawful presence? You have to say yes. You have to say yes. But that by itself does not cause them to deny your L1, as long as the unlawful presence is less than 180 days. Sponsor H1B visa. I have a small registered company with 4 people, including me. All green card holders want to file an H1B for somebody. They are here on L2 EAD. Can I sponsor his H1B for the year 2014-2015? Definitely. What are the documents I need to provide as an employer for his visa sponsorship and processing? Well, that's a difficult question for me to answer. You have to prepare certain documents, and you can go to the Department of Labor website for general information. But basically, you need to have, if you're going to place this person at a contract at a client site, you must have a letter from the end client that describes the project, describes what their relationship with your employee is, describes what the terms of your contract are, how long it's going to last. So end client letter is very important. If you have an in-house project, then you should be able to flesh it out, what kind of project, how many man hours it would take, who's working on it. So that is the important documentation. Rest of it is routine. Name changed. I'm a US citizen. Filed for my brother and his wife and son who are in China. I-130 was approved. Files were transferred to NVC. They are waiting for the visa to become available. Brother's son had his name changed. Yes, contact NVC, absolutely. Contact NVC. You can actually call them. It takes all day to get through, but they are good about responding. You can also email them, and they'll tell you what procedure to follow. Okay. This can be done at the consulate, but it's better to do it at the NVC as early as possible anyway. LM, which is again same person, add a newborn child after I-130 was approved. It can be done anytime, but again, contact NVC. You could actually do it at the consulate, but do it at the NVC. It'll save you a lot of hassle. Just contact them; they'll tell you what you need to do. B. Henry, husband has conditional resident status, but she should have been issued 10-year green card. You're right. If somebody has been married for 2 years already, they should have gotten a permanent green card. Okay, so you can contact USCIS customer service and find out what happened and why he was not given a, a green card without any condition on it. Okay, maybe they have an explanation that we don't know about. Give them a call. Ready 47, currently on OPT with expired F1 visa, planning to apply for H1 in regular quota. Our university students are not eligible for masters. How do I plan for my future? Well, you have only two obvious options, H1 and then continued F1. Okay. Other than that, what else can I tell you? H1 is, as you know, it's a lottery. You get it or you don't get it. If you don't get it, you have to decide, am I going to leave USA or I'm going to convert to a different status? So, okay. Unfortunately, I can't tell you anything more than that. Shanda is talking about changing jobs. My PR application has been filed in EB2. Company lawyers received the I-140 approval. If I change my jobs and the new job is completely different, current title is Senior Manager in Global Regulatory Affairs and Safety. New title is Senior Medical Affairs Manager. Different salary scale, different company. Can I do that? And I just had a very lengthy discussion about that a couple of seconds ago. And I said, you can transfer the priority date upon the I-140 approval to any job anywhere. You'll have to start your green card all over again. Okay. What is the process? For example, say I get an offer from the new company. Is it okay for them to file for my H-1B without me having informed my current employer? Yes. Yes. They can. In fact, the smart thing to do is, because your I-140 is approved, even if you went over your 6 years of H1 or 5 years of H1, you are entitled to a 3-year H1. And you do it through the new company based upon the I-140 of the old company. Once they get the 3-year approval, only then you should resign and join. Give notice, resign, and then join. Okay. What are the things I should be careful about? That's not something I can tabulate. That's a book. Basically, remember, you just need to file your second green card as quickly as possible so that if the old employer revokes the I-140, you would have no other grounds to continue to extend your H-1 beyond the 3 years that you already have. So if you have started your second green card, it will then become a basis for further H-1 extensions. For my extension of H-1B to be filed, the I-140 should be approved at least 1 year in advance. There is no such law. Once the I-140 is approved, you're entitled to 3-year H-1 extension with any employer. There is some confusion about who can revoke. The old employer can revoke the I-140, but that does not take away the H-1 extension that you've already been given, and it does not take away your priority date. And you can have a totally different role and still carry the priority date forward. Okay. So the only thing I would watch out for, well, two things. One is make sure that you join the new company only after you get the 3-year H-1 extension, and two, the new company starts your green card as soon as possible. They do that, the company is solid, and they are behind you, you should be okay. Pasha wants to know, can I open H-1B expired petition? My H-1B visa validity October 1st, 2008 to September 20th, 2011. I haven't visited US consulate due to my personal problems, so he has not used it. Can my H-1B be extended through same employer or another employer? And the answer is yes. You are not subject to the quota. They will have to start a new H-1 for you, but it will be it can be the same employer or a new employer, and you're not subject to the quota. That's what you need to know. Okay. Well, I'm done with the questions that were posted. First, let's take any follow-up questions. No new questions, any follow-up questions. Press *5 on your phone, please. *5. 1 question, 2 questions, 3 questions. Okay. I'm going to start in the order in which you called in. So, Michigan, go ahead, please. Michigan.
Hello, sir. It's Need City. So I just want to
I'm sorry.
check my understanding.
Which number? Which number question are you, sir?
16 number, Need
Okay.
City.
1 second. L1 extension denied. Yes, go ahead, please.
So, sir, if I go back to India and at the same time my employer appeal for the denial, so I can still go for blanket L1 visa until like appeal decision comes.
You can do
Am
it.
I right?
You can do it before the appeal decision comes. I don't see any problem with that.
Okay, thank you, sir. And another one, another question is, if I say yes, so I just need to mention the reason. Okay, it got denied, and within
Yes.
like
Yes.
20 days I left because I am
Yes.
living on 26th now.
No problem at all. I don't think that's going to be an issue for you at all.
And last question, if I come back on L1 visa, so will this denial create any problem in my GC processing?
No.
Thank you, sir. Thank you very much.
You're welcome. Good luck.
Thank you, sir.
Bye-bye. New York, go ahead, please. New York.
Hi, good afternoon, sir. This is Vaisak, and it's regarding question number 12.
12. 1 second, sir.
Regarding
I-90.
filing the I-90
Sure.
Form 90,
Yeah, as
and
far
the
as
person is outside the country.
it cannot be done from outside USA, as far as I know.
Right. Okay. On the form, it says you must file Form I-90 while in the United States.
Right.
My question is, say, if it's for my spouse and she should be present when the filing reaches USCIS and she can leave immediately?
I do not know the answer to that
Say
question.
if she is
I do not know the answer to that question. I've never confronted that situation, so I've never looked into it. There are 3 kinds of forms. There are some that do not allow you to leave at all. If you leave, you abandon the whole application. There are some, like Form I-131,
Okay.
where you can leave after the filing. There are some where you can file from outside USA, like N-470. Okay. I'm not sure which category I-90
Okay.
falls in. I would strongly recommend talking to USCIS customer service.
Okay. Thank you very much, sir.
You're welcome. Good luck.
Thanks.
Okay, last question from the old set of questions. California, go ahead, please. Campbell, California.
Hi. Hello. Yes. Can you hear me, Rajiv?
I can.
Okay. So this is question number 15. I apologize. I could not hear your answer because I was stuck in traffic. So is it possible for you to tell me what was your answer?
I hate to keep repeating myself because I've already recorded this and you'll have it up anyway. Let's not do this time and again, but I'll make an exception this one time. I do not like doing this. I said that because tourist visa can be filed or tourist status can be filed online. So therefore, if you get laid off today, you can actually file it, come home and file it online today itself. Okay. So
as long as I file on the same day, the day on which my job gets terminated, I'm fine, right?
I prefer to get filed the day before, but if you cannot, I think that's quite close to the cusp and you should be okay in my view. Okay.
And if I file right now, although I'm expecting that my job will be terminated in 2 weeks or so, is that still fine? Because I would still continue to remain on the H-1B visa until my job stays, and then the pending visitor visa petition will keep my visa status valid.
You can, and you can do it by mail. And if something happens and the job continues, you can then withdraw the application for tourist visa.
Okay.
Okay. Now, I also mentioned that if you apply for an H-1B through a new employer while the tourist visa is pending, that becomes quite complicated because they will not give you an H-1B status within the United States unless on the date they decide the second H-1, your tourist visa is already approved. If it is not approved or if it has been denied, they will ask you probably to go outside USA for visa stamping.
But if that visitor visa petition is still pending, what will they do with the new H-1B petition for the new employer?
They can approve the H-1B, but ask you to go outside for visa stamping. So they won't give you status.
I see. Okay.
Okay.
All right.
And one denial
I
out
do have a
of
follow-up question.
one denial out of 24
Yes.
doesn't bother me.
I'm sorry. On denial, what?
You asked me a question about a denial out of 24 applications. That doesn't bother me.
Okay. All right. I have one follow-up question. So, because my current H-1B petition, my current I-94 is valid until February 1, 2015, which is only 14 months away, and the new employer will file for a green card petition once I join them, as soon as I join them. Because that process takes whatever time, 2-3 months of documentation, etc. Is it advisable for me to spend some time on visitor visa while the employer is preparing the documentation so that I do not miss the 1 year deadline, 1 year before the end of H1 deadline to file green card labor certification?
That's something, the timing you should discuss with your green card lawyers. Okay. There is no law that says you have to be on H-1B with that employer before they can file your green card. So discuss it with your green card lawyers how they want to time it. That's something I cannot comment about. Okay?
Okay.
Anything else I can
All
help you
right.
with? Anything else?
Yeah, I mean, I think that is all. That is all.
Good luck to you, sir. Good luck. Okay, folks, anyone has any question, press *5 on your phone. Any question at all. New question, old question, doesn't matter. Press *5. Okay, 2 questions. Very good. I'll get started in the order that you folks logged in. Sacramento, California, go ahead, please. Sacramento, California, 916669. Go ahead.
Yeah, this is Mohan Kumar here. This is a continuation of question on question number 11. So myself, I am on L2 EAD. You rightly mentioned like my employer can sponsor my GC.
Right.
Parallelly, can I apply for GC myself?
I do not know.
On EB2 or whatever?
I said that you should look at the criteria for an EB1. Not everyone, just because they have a PhD under the current law, qualifies for EB1. Okay.
Yeah, because I looked at the criteria under the website immigration.com, like
right.
3 out of 10 rule.
Right.
I suppose like I have like 4 of them, like a publication, presentation,
it's not
those kind of things.
Let me make one thing clear to you. And this is a little bit more complicated than it looks. For example, if they say publications, they ask you many things. First, they'll ask you, how many publications do you have? Second, what is the impact factor of the journals in which you have publications? Third, how many people have cited you, not including yourself and your team members who did the research? 4, what is the significance of your publications? They don't ask that question so much in EB1B, but EB1A, which is self-petition, they ask that question in detail. So not only must you have publications, you must be able to explain all these things. What I can do is, you can email me your resume, help@immigration.com.
Sure.
I'll take a look at it. And there's no charge for that.
Sure, I'll do that. Thank you very much.
Good luck.
Yeah, can I?
Sorry, Mohan, go ahead, please. Mohan?
Yeah, sorry, I have the question related to the number 1 question, that is, can I apply for GC if my employer is ready to sponsor?
Definitely.
So again, okay, if my employer applies for a GC and whatever category, and like I have a validity of my EAD for another year and a half. So what if I
what steps I need to get clear to stay back in the country?
Oh, long ways. Are you India born?
Yeah,
Is your wife also India born?
yes.
Okay, well, you have to wait almost 5, 6, 7, 8 years before you can get to that safe position. So you'll have to convert to an H1B somewhere along the line.
Okay. Thank you very much, sir. I think this makes more sense. Yeah.
You're welcome. Good luck, sir.
Yeah, sure.
Okay, we have 2 more questions. Michigan, go ahead, please. Michigan.
Yes, sir. So it's another follow-up question on number 16.
16 or 15? 16 or 15?
16, sir.
Okay, got it. Yeah.
No. Yeah. So if I go back to India, so can my company file GC while I am in India?
No problem at all.
Okay.
Okay.
Thank you, sir. Thank you very much.
You're welcome. Good luck.
Thank you.
Okay, guys, last question of the day. Campbell, California, go ahead, please. California.
Rajiv, this is question number 15 again.
1 second. 1 second.
So, as you mentioned, 1-5.
Right, I got it.
This was, yeah. So, you said that if I file for my visitor visa even now, which is maybe 2 weeks before I get terminated, and my visitor visa petition is pending at the time the new employer files for the H-1B petition, I would have to go and get the stamping outside of the country.
I don't say you would have to. I say it is possible. That appears to be the worst case scenario.
Oh, okay, that's the worst case scenario.
Yeah,
it's
see,
not a necessary condition.
If your tourist status is approved, by the time USCIS is ready to adjudicate your H1, they will give you H1 within USA. But if it is not approved, it's pending or denied, then you'll have to go outside.
So I looked at the timeline for how long it takes to adjudicate the visitor visa petition in California. It takes about 2.5 months. And because the new employer will file for the H1 petition in premium, they will decide the H1 before the visitor visa petition will be decided upon. So which means my visitor visa petition will indeed remain in pending status at the time the H1 petition will be decided.
You can request the government for consideration and request status within the US, but they are unlikely to give it. Unlikely. Not impossible, but unlikely.
I see. Okay. So if hypothetically, if they decide to give me H1 status in the US, then what will they do with the pending visitor visa petition?
You should revoke it, withdraw it immediately.
Oh, I do have the option to revoke it at that point of time.
It's your application. Anytime before approval, you can withdraw it.
I see. Okay.
I used the wrong.
I was confused that once my H1 petition.
No. I was actually. You know what I would do if I were you? Let's say you come to find out that they've sent you an RFE about status, etc. In that RFE response, I would state that please give me consideration and approve my H1 status within USA. And if you are going to do that, consider my tourist visa withdrawn. You can do that in the same letter. Attach a letter, separate letter saying if my H1B status is approved, I request that my tourist visa be withdrawn.
I see.
Okay.
Okay. All right.
Anything else?
Okay. Yeah, I mean, I think I don't see any downside to applying for the visitor visa right now, even 2 weeks before the termination.
I don't either.
I don't know what date.
I don't.
What is the down?
I don't either. I don't see any downside. Sorry? It's a reversible decision. I don't see any downside. Okay.
Okay. That makes sense.
Well,
okay.
Good luck to you, and I'll talk with you again, everyone, in 2 weeks. Thank you all for your time. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.